is the sound guy controlling them?
I think this is on. Angela is going to introduce, it's going to start it, get everybody in the room. So we'll just wait for her. The secretary went a little over.
She's entitled.
We'll let her do that.
Yeah, that's okay. That was a great interview.
Yeah, she did a good job.
I will always have particular fondness for Betsy. And,
Oh, absolutely.
but it was nice to see the current secretary.
Oh yeah, she's a good egg. She's a
Betsy
good
was
egg.
such a
I got to
sweet
know her
person.
during confirmation and transition, and she's good. She's a good egg.
Yeah.
How's she doing these days?
Betsy,
Yeah.
I have not seen much of her. She's been traveling.
That's
She and
probably a
Dick have
good
been
sign that we
traveling,
can
like far away type travel.
Good.
So I haven't seen her for a while, but I hear she's doing really well. She's focused on a lot of family stuff these days.
Well,
Family
I
stuff.
don't use the term DEI.
Understood.
But yeah,
I don't
what I'm
either.
going to do is sort of introduce with like one sentence various ways the ABA can go wrong, but then launch into detail on that. And I'm assuming that you're going to go second. Is that right? Because I think that works better. Yeah.
I've got my bill of particulars.
Yeah. So I probably, I'll mention, I was going to mention the experiential learning requirement, just to mention. Yeah. And I figured,
Just the latest example.
yeah, no, I think it's kind of pretty interesting one. And
It's a very interesting way, and it for me, 40,000.
It was definitely.
Just an example of how the ABA does things, and they don't listen. I mean, deans,
And it's hard because
the deans
started.
there's so much bad press about me, and my mother doesn't
they just
any
well,
of this
okay,
work.
but
You know, she just sees
you
the
know, we're gonna
headlines.
do what
and
we're
people
gonna
in
do.
her
I was shocked
retirement
when I heard that, like, they just ignored all this input. I mean, it just,
I mean, at least to date, they seem.
I mean, my kids
they
understood.
sounded
because
pretty
they had-
strong.
Yes.
They-
Yes. Oh, we're gonna do what we're gonna do.
So many people
Well,
read stuff like, you know.
another thing is,
I
who
have
are
friends
you?
that say, oh my
I-
God,
I
you're
don't-
not the person you used to
And
be.
why do they
No, I'm
want
still
such
the same person.
uniform
This is not.
legal education? I mean, that's
But people
what I
outside
don't
love
understand. I mean,
And that's the hard part.
why impose your vision on every law school in the country?
My personal theory is it's because they can. I mean, and obviously, they're a monopolist. That's how monopolists behave.
Nothing ever gets easy, I can imagine.
Try to be fair. Try to be gracious.
It's, you know, it was helpful. It was, you know, at least my kids were adults when I was in the Bush administration.
Oh,
My kids were
okay,
still
we'll
young,
start.
so it was
No, it sort
Thank
of
you.
shows
All
how
right.
much power the kind of person that
Welcome back, everyone. Please find your seats as we welcome Bob Eitel, DFI President and co-founder, back to the stage for our first plenary session titled Reimagining Law School Accreditation, Possibility or Pitfall. Thank you to the panelists for being here. Bob, I will turn it over to you.
Thank you, Angela. I am the nameless moderator. I don't get a placard for reasons I do not understand, but I think most of you know who I am. And with me today, and I'm delighted to host an all-star panel of Diane Jones, Stig Leschly, Czarnetzky, and Gail Heriot to talk about the issue of law school accreditation, possibility or pitfall. Let me just start to say one thing. When we say ABA in reference to this discussion, we realize that it is not the ABA per se, but it is the Council of the Section of Legal Education and Admissions to the Bar, which serves as the nation's only accreditor for programs leading to a JD degree. We'll just say ABA for shorthand. It's much easier than saying the Council of the Section of Legal Education Admissions and Admissions to the Bar, so we'll do it that way. In many states, graduation from an ABA-accredited JD program is a prerequisite for taking the bar examination or practicing law. For freestanding law schools, the ABA, as the nation's only Department of Education recognized accreditation agency for legal education, also serves as an institutional accreditor for the schools, without which they would lack eligibility to participate in the federal student loan program. For going on, I think, 30 years now, frankly, for as long as I've practiced law, I have heard attorneys, mostly, but not always conservative ones, complain about the ABA and the role that it plays not only in the profession, but in the accreditation of law schools. Frankly, despite the complaining about the ABA, I've never really heard much discussion about any real effort to consider whether there should be an alternative agency or an alternative to the ABA as a law school accreditor. So I think with this panel today, we'd like to get this conversation started. So this panel asks whether it's time for a new accreditation agency for legal education. If so, what is the concern about the ABA that would prompt such a question? If there is interest in a new agency, what are the organizational, operational, financial, and regulatory challenges to standing up a new law school accreditation agency? What are the benefits of accreditation? We sort of presuppose that accreditation is important to a quality law school. Do we even need it? Is accreditation even desirable, whether or not the ABA or some other agency does it? What's the role of the education department in all this? I do want to leave room for questions, so what I will do here is I will introduce our panelists with brief overviews of their biographies. I will not go into their biographies in depth. You can look them up. I think their reputations precede them anyway. And then we'll go into we'll have each give about 5 to 10 minutes overviews of the areas that they're going to be speaking about, and we'll go from there. But think about questions you might want to ask. Well, we should have the microphone is right there in the middle. I'll announce when we'll move to questions so you can come up and get in line. So first, Gail Heriot most recently served as a professor of law at the University of San Diego. Her work has appeared in legal journals like the Michigan Law Review, the Virginia Law Review, and the Harvard Journal on Legislation. She frequently writes for popular newspapers and magazines, including the Wall Street Journal, the National Review, the LA Times, and the San Diego Union Tribune. She has been a member of the U.S. Commission on Civil Rights since 2007. She graduated with the highest distinction from Northwestern and earned her JD with honors from the University of Chicago Law School, where she served as an associate editor of the Law Review. She is a member of Phi Beta Kappa and the Order of the Coif. Dean John Czarnetzky has served as the Chief Executive Officer and Dean of Ave Maria Law School since 2021. He is a graduate of MIT and the University of Virginia Law School. He joined the University of Mississippi School of Law in 1994, teaching courses in bankruptcy, corporate reorganizations, secured transactions, civil procedure, and business associations. At Ole Miss, he was the 5-time winner of the Outstanding Law School Professor, and in 2016, he was the recipient of the LCM Hood Award for the Outstanding Professor at the University of Mississippi, the highest honor awarded to faculty members at Ole Miss. Dean Czarnetzky also serves as legal advisor to the Holy See's mission to the United Nations, representing the Holy See in negotiations, including establishing the International Criminal Court and several international treaties. He is a lay member of the Dominican Order and a third-degree Knight of Columbus, and before law school, he was a U.S. Army officer. Stig Leschly is the founder and president of the Post-Secondary Commission, a new innovative institutional accreditor of outcomes-focused and innovative colleges. PSC is currently seeking formal recognition from the U.S. Department as an accreditation agency for institutions. Formerly, he was the CEO of Match Education, an education-related nonprofit that runs charter schools and trains teachers. Early in his career, he was a high-tech entrepreneur and an executive at Amazon.com, so I can blame you for all the packages that come to our house on a daily, hourly basis. He is the co-founder and board chair of Duet.org, a hybrid college that operates in partnership with Southern New Hampshire University, and has been a senior lecturer on entrepreneurship at Harvard Business School on and off for more than 20 years. He received his JD from Harvard Law School, his MBA from Harvard Business School, and his BA from Princeton University. Diane Jones served as Assistant Secretary for Post-Secondary Education during the George W. Bush administration and as the Acting Undersecretary of Education during the Trump administration. More importantly to today's conversation, she served as the Senior Department Official for Accreditation Agency Recognition during both tours of duty at the Department of Education. She has seen the good, the bad, and the ugly of the department's recognition process. Is it mostly ugly or just, okay, we'll get into that. She has worked at institutions of higher education ranging from a community college and a for-profit institution of higher education to Princeton University. So she has seen accreditation from the institutional perspective. She has also been the president of an accreditation agency, so she brings multiple perspectives to this discussion. So here, I think here's how we'll go. We'll start with Gail, and I think it's upon us to sort of lay out what, if anything, is wrong with the ABA's handling of law school accreditation. Is there an indictment to be made, and if so, what is it?
Let me count the ways here. There are a lot of ways that a law school accreditor can go wrong, and over the years, the ABA has pretty much done all of them. It can act as a labor union for lawyers by trying to limit entry into the profession and thus keep earnings up, or it can act as a labor union for law professors like me by insisting that professors get sabbaticals and other perks. Or it can act as an advocate for law schools vis-a-vis the central administration by issuing an ultimatum that if it doesn't build a palatial new law school for the law school building, then the school may be de-accredited. And at one point or another, the ABA has done these things. Another way that accreditors can go wrong is to impose their vision on legal education, in this case, on every single law school in the country, such that each one has to be just like the others. And the ABA's current effort to increase the experiential learning requirement from 6 hours to 12 hours fits into that category. But I want to talk about a different abuse right now, one that for the ABA dates back to the 1990s. The ABA wasn't the first accreditor to attempt to dictate to the institutions it accredits the minimum levels of racial diversity. The Western Association of Schools and Colleges and Middle States beat them to that. But the ABA is perhaps the most zealous of the accreditors on this issue. In the late 1990s, political scientists Susan Welch and John Gruhl set about to find out whether any outside pressure, and I'm quoting them here, to take race into account in making admissions decisions. Where's that pressure coming from, they asked. And they asked law schools and they asked medical schools. And the question was, is it coming from the federal government? Is it coming from state or local governments? Is it coming from outside groups? In which case, which groups? They didn't specifically ask about accreditors. I guess they didn't know to. But nevertheless, 31% of law schools and 24% of medical schools responded that they had felt pressure from their accreditor. So if you are thinking, well, yes, but the ABA would never dream of playing hardball on such an issue, yes, they would. The case of George Mason University's law school is now the paradigm case that every law school knows about. They know that when the ABA demands more racial diversity, they had better jump because the ABA means business on this. The story begins a while back now with the ABA's site evaluation team visit to George Mason in the year 2000. The site evaluation team was unhappy that only 6.5% of George Mason's day students and 9.5% of its evening students were minority members. Nobody could argue that GMU's problem was lack of outreach. The site evaluation team conceded that GMU had, and I'm quoting here, a very active effort to recruit minorities. It described those efforts at length in the report. It noted, however, that GMU had been unwilling to engage in any what they called significant preferential affirmative action in admissions. Since other schools at the time were admitting minority students with dramatically lower academic credentials, GMU was at a recruitment disadvantage. The site evaluation team noted its serious concerns, as it said, not with the other schools, but with GMU's policy. Over the next few years, the ABA repeatedly refused to renew GMU's accreditation, citing its lack of significant preferential affirmative action program. Although GMU could and did step up its already extensive recruitment efforts, it was forced to back away from its opposition to significant preferential treatment. That enabled it to raise the proportion of minority members in its class to 10.98% in the year 2001 and to 16.16% in 2002. Not good enough. The ABA did not want slow, thoughtful movement in its direction. It wanted utter capitulation. Shortly after the Supreme Court's decision in Grutter versus Bollinger, an emboldened ABA summoned the GMU president and dean and threatened them with de-accreditation. That, of course, would be death to the law school, since its graduates would not be able to take the bar exam in most states. GMU responded by frantically lowering its standards still further and further expanding the resources devoted to the diversity recruitment. By 2004, GMU had 19% minority members in its entering class. Not good enough. Now the ABA was upset that only 23 of its minority students were Black. To the ABA, GMU's skepticism about race preferences was heresy, and they were determined to make an example of it. They wanted academic standards lowered to alarming levels. GMU did what they had to do. They complied. Not until 2006 did GMU get its reaccreditation, just in time for the next round of its 7-year accreditation process. And guess what? They were cited for lack of diversity again. Meanwhile, an important question wasn't being asked. What happened to the students who were admitted with these lowered academic standards? And the answer is just what you would expect. Black students experienced dramatically higher rates of academic failure as defined at GMU, and they defined it as a GPA of below 2.15. Fully 45% of Black students experienced academic failure, as opposed to only 4% of students from other races. In a letter to the ABA, then Dean Dan Polsby put the matter very plainly, and I'm quoting him here. "We have an obligation to refrain from victimizing applicants, regardless of race or color, by admitting them to an education program in which they appear likely to fail." But the ABA wasn't listening. It was busy toughening up its diversity standards. They were riding high then on the Supreme Court's decision in Grutter versus Bollinger. If they hadn't made it clear enough from the way they treated GMU that efforts were not going to be enough, one needs results, they were making it clear through their new standards. One of the most interesting parts of the new standards declared, and I'm quoting here, the requirement of a constitutional provision that purports to prohibit consideration of gender, race, or ethnicity in admissions or employment decisions is not a justification for a school's non-compliance with the new diversity standards. What were they talking about there? It was all about Proposition 209. In 1996, California voters had adopted a popular initiative that I had more than a little bit to do with. It amended the state constitution to prohibit state-sponsored preferential treatment on the basis of race, color, sex, ethnicity, or national origin. So just what was the ABA advocating? Was it asking state universities subject to Prop 209 to violate the law? Well, after some hemming and hawing, the ABA essentially responded by saying, perish the thought. Schools don't need to violate the law. They can achieve this kind of diversity that we require in other ways. But by hook or by crook, they need to do it. But it was all disingenuous. When the Grutter versus Bollinger case was pending, the ABA had submitted an amicus brief that insisted that adequate diversity cannot be had without resort to preferences. Then a few years later, in the Fisher versus University of Texas case, they did the same thing. They told the Supreme Court that it cannot be achieved without preferential treatment, and yet somehow they were telling California schools, and by then, of course, similar initiatives had been adopted in Washington State and in Michigan as well. Just this year, the Pacific Legal Foundation did a round of FOIA requests to the top 50 state law schools. Of the 45 schools that responded, 20, and this is just in the last round, had been cited for failure to meet the ABA's diversity standards. I can tell you that my own institution, University of San Diego, a private school, we were told that if we did not hire more women for our faculty, we were going to have trouble. And I can tell you how this works internally as well. You know, at any given law school, there are going to be people who are gung-ho for preferential treatment, gung-ho for this kind of admissions policy. But there are also going to be faculty members who are against it, or who might be somewhere in between, saying, okay, I'm willing to go for a little bit of this, but not a lot. The ABA, by weighing in on the side of those who are most enthusiastic about preferential treatment, upsets the balance of power within the faculty in that way. This year, the ABA has announced that it will pause its diversity requirements. And one would think the Supreme Court's decision in SFFA versus Presidents and Fellows of Harvard College, one would think with that the ABA would have wanted to back off a couple of years ago. Instead, what happened this year that might cause them to want to do it this year?
I can't imagine.
At any rate, they didn't say that they're ending it. They said they're pausing it. So from the sound of it, as soon as the Trump administration is over, they intend to go back to their old ways. So I think the only solution to this, given the way the current legislation reads, we need legislation aimed specifically at this problem. Tell accreditors that the racial and ethnic composition of the classes and the faculty is just not within the range of issues that they are allowed to consider. Senator Jim Banks of Indiana has introduced such legislation, and I support it. But let me save that discussion for a little bit later, because I think I've used up my 10 minutes.
Thank you, Gail. John, your law school has recently undergone the pleasure of an ABA accreditation cycle. Would you give us your experience with that and your thoughts on the issue as well?
Well, I'd be glad to. Just preliminarily, it's a real honor and pleasure to be on this distinguished panel, and so thank you for inviting me. And to those of you that might be a little suspicious about having a law school dean on the panel at a Federalist Society event, let me just say, for what it's worth, I've been a Federalist Society member for over 35 years. I am dean. For those of you unfamiliar with our school, the title of the school may give this away. We are Ave Maria School of Law, is a genuinely and seriously Catholic law school. And what that means in the cultural moment we live in is that we're also a very conservative law school, one of a small handful. With that context, our school did 3 years ago, go through the ABA site visit. And what that means is every 10 years, the ABA sends a site team, and they examine every aspect of the law school. And I do want to be fair. I mean, I am a law school dean that's going to give a bill of particulars against his regulator. So, I am a little bit abashed by that, but I won't hold back. I do want to begin with some praise for the ABA, some gentle praise. Everyone on the ABA staff the ABA council staff that I've dealt with have been unfailingly polite and professional, and that includes the site team that came and visited us. Now, please, distinguish unfailingly polite and professional from the pure power that, Gail alluded to this, that the ABA Council exerts over us. Perhaps it's easy to be polite when you know you're carrying the big stick. But, I mean, I do need to say, nothing but professional treatment from the ABA Council staff. But, okay, let's cut to my experience, or law school's experience, with ABA regulation. And again, Gail has alluded to some of these points. And I speak from the perspective, obviously, as a law school dean. In no particular order, first, the ABA, as a monopolist, and that's what they are, displays hubris in my mind. And nobody says this. In fact, some members of the ABA Council might be surprised to hear somebody say this, but for me, it's unmistakable that the Council's mission goes beyond sort of consumer protection, being sure that law schools are preparing their students to take the bar exam and become lawyers. To me, that's silly me. That seems to me to be the mission of an accreditor of law schools. I think, and I think just a few of the things that Gail mentioned, and we could go on and on, regarding the ABA standards, their behavior indicates to me that they have a strong sense that they are going to shape the legal profession, nothing less than the legal profession, not just the legal academy, but the profession, with starting in law schools. We can talk more about that. Some things that I've learned as a dean that as a law professor I was spared from. For me, and again, I can't prove this, but the council seems to be captured by outside influences. I don't mean to be coy in that statement. I have heard, because we have dean's meetings every year, and the ABA Council, usually at least one of the members comes to those meetings, which I applaud them for, and I have heard at such meetings ABA Council members saying, well, you have to understand that this standard X, comes from input that we have received, very strong and ardent input that we have received from unnamed sources. Okay, I'm not sure that I guess the analogy to that would be legislative capture or something like that. The one group, or at least from my perspective, the one group, the ABA Council, is not super interested in having detailed discussions with are law school deans, or at least law school deans of sort of modest law schools like mine. I found myself at the last meeting talking to two deans of very prominent law schools, and they felt the same way, but of course that's not a scientific study. So the ABA is captured. They don't seem to be captured by the Federalist Society, but they...
Go fix that.
or DFI, for example, but they do seem to be captured by, let's be polite and say, interest groups of different sorts, and that, to me, is, in my opinion, is reflected in their standards. Next bullet point, the ABA Council itself, the ABA Council itself, from my perspective, is a black box. I mean, you can read, they publicly disclose who they are, and you can read their backgrounds, but I'm a little bit confused, although I can guess, what it takes to become a member of the ABA Council and who makes the decision. Bob referred, I think, to the fact that the ABA Council is actually almost independent of the ABA itself. In fact, when you hear council members talk, they are at great pains to make that point. Look, it's a huge misunderstanding. We're not part of the ABA. And I take it that's because the ABA takes some very problematic positions, in my personal opinion. But to me, that's even worse. If they were part of the ABA, then we could apply pressure, whoever that is. Pressure could be brought to bear, let's use the passive voice, on the ABA as an institution to reform the council and to perhaps be less opaque. But the council is this sort of free-floating entity that is just tenuously tied to the ABA. To me, that's worse, because now I'm really confused about how you get to be a member of the ABA Council. I'm not foolish. The answer, I think, I am willing to be corrected, is that the council is a self-perpetuating entity. And so, you know, this black box, in order to gain entry, you have to, you know, be friends with the people inside the black box. So opacity, I would say, is a definite problem with the ABA Council. Most important, I think, and it's related to some other things I just said, for me as a law school dean, is the ABA Council overreaches in their, in my opinion, attempt to shape the legal profession. Their standards reflect a best practices approach to running a law school. And there's nothing wrong, I guess, with best practices, but at Ave Maria School of Law, we have a different mission than many law schools. We're proud of that mission. We think it's the way to train lawyers, and it doesn't always comport with the best practices of, you know, let's say one of the top 20 ranked law schools that have all the money in the world. So there's significant overreach. I probably should have chosen a better way to put it, but in a discussion of this with some ABA folks, I said, every time you guys put out a new standard or even a suggestion for a standard, it cost me $50,000, and at a minimum. And that's just to plan for the standard becoming, and $50,000 at Yale Law School, you know, that's nothing. For my school and for many, many ABA accredited law schools, that's a lot of money, which is why I chose the number. Overreaching, when, especially keep in mind, you all know this, keep in mind, law schools, unlike many other educational institutions that are accredited, we have an absolute test of whether we are accomplishing our mission, and that is bar exams. We have an absolute test whether we are doing what we should be doing. Do our students, former students pass bar exams, and at what percentage do they pass bar exams? So in any event, I am skeptical about many of the ABA standards that I consider overreach, given that we have an absolute test that is public knowledge. In fact, if you're so disposed, pray for us. 1 week from today, the Florida bar results come out. And so I am saying my rosary every day for that. Another thing it surprised me, but upon reflection, it makes sense, but perhaps you hadn't heard of, as I hadn't. There are a number of law school deans. I can't quantify it, but I've heard it at every dean's meeting I've been to. There are a number of law school deans that are complicit with the ABA. For every law school dean like me that makes the complaints that I make, there are deans that say the following: thank you, ABA, for your latest standard, whether it's the experiential requirement or the affirmative action type requirement. Thank you for that, because that allowed me to go to my faculty and say, sorry, we all may be against this, but the ABA requires it. So, you know, that's an interesting, I don't know, legal academy cultural issue. You have co-governance. What co-governance means is on a very limited number of items, faculty get a vote, which administrations have to pay attention to. I'm just being polite. And the ABA standards, these, as I call them, best practices approach to the standards, gives deans the ability to move forward what is their agenda anyway within their schools. And so we have to keep that in mind, that not all law school administrations are against the ABA's approach. Final thing I want to say, and then I'll subside, is just a very particular point for my law school. As I said, Ave Maria School of Law, you can guess, is a very seriously religious school, and there are about 20 or 25 law schools in the country that are, to one extent or another, religious, and how that impacts their mission varies between each school. When the ABA conducted their site visit for us, it was clear to me that, and I'm trying to be charitable, but that no member of the site team was at all intimately, or even maybe not at all familiar with the unique mission of a religious school, much less a school that takes that mission as seriously as we do. So just as a small example, and it really is illustrative of the ABA's council's power, and it's almost as if maybe they don't recognize it. So just very quickly, the ABA required law schools 2 years ago, I think, or 3 years ago, this provision was put into the ABA, to the standards for accreditation, that our anti-discrimination statements, both for admissions and for employment, would guarantee that we will not discriminate based on gender expression. Not gender identity, that was already in there, but gender expression. Now, regardless of how one feels about that point, that we believed would have violated Catholic Church teaching. And for Ave Maria, we're not going to do anything that violates Catholic Church teaching on these type of issues. So I told the ABA, the site team, we're not going to do that. And the first thing they said was, well, that's interesting because there are a number of other Catholic schools that have no problem doing this. I said, well, okay. Okay, but we do have a problem. What I really wanted to say is, why is the ABA crafting their own anti-discrimination statements when the Department of Justice has an entire division that's perfectly capable of policing schools that are violating civil rights? And by the way, the idea that any law school in the country is consistently violating anyone's civil rights, well, except in recent Supreme Court cases, is preposterous, at least violating rights in the way the ABA is worried about. Anyway, so we told the ABA no, and I told them, well, I'm not going to name any schools, but just because school X does something doesn't mean that that's what the church approves. And what happened, just to cut to the chase, was the ABA council said, okay, we've met, Dean, and we can't sort of reaccredit you until you show us that this is actually church teaching. Well, okay. So I sat down and wrote a catechism on this issue based on Bishop's teaching, and I wrote back to them. And so think about this, okay? My school is up for reaccreditation. The ABA has all the power. They send us a letter that says you are out of compliance with our standards and therefore not accredited. That is an existential crisis for our school. And we're an independent school, so I report to a board, and they want to know what's happening. And so I write to them. They wrote back and said, well, we're still not satisfied. Amplify your catechesis, which I did. And then after a year, because the council has to meet, they discuss, they vote, after a year, they wrote back to me and said, just one sentence, after consulting with outside counsel, notice that. That's a Godfather kind of statement, right?
It's a nice law school you got there. Wouldn't want anything to happen to it.
Be a shame if something happened to it. Good line, Bob. After consulting with outside counsel, we find that Ave Maria School of Law is in compliance with ABA standards. However, and you can see how this happens. I don't mean to be overly critical, but I do mean to be critical. They said, in consulting with outside counsel, we are not we would like you to explain to us how you give notice to both students applying, potential students, and employees. I was so tempted, and it's a character flaw of mine, to write back one sentence saying, we give notice because we are known as Ave Maria School of Law. I didn't.
It's a hint.
And I wrote them, as a former Civ Pro 1 professor, I wrote them a detailed discussion of how we satisfy Mullane case. So sorry, I should have given you a trigger warning for that. But in any event, now I know I've gone over my time, so I pass.
Thank you. Stig, you are creating an accreditation agency. You're undergoing, I think, Department of Education review. Would you give us your thoughts and perspectives?
Yes. And Bob, thank you. And to Jim, thank you, and the DFI team and the federal side, and all of you really for coming here and for taking an interest in accreditation. It's an immensely important institution in our society. And until of late, nobody really talked that much about it other than Diane and her friends. So thank you for that. And I will be brief because I'm sitting next to Diane, and she has forgotten more about accreditation than I'll ever know, or any of us. I'll probably stick to 2 points. The first one is just to remember for all of us why accreditors are powerful. We'll talk a lot about their dysfunctions, I'm sure, and about the promise of building some new ones, but why do they matter? And it's essentially for two reasons. They gatekeep jobs, and they gatekeep money. They gatekeep jobs, and they gatekeep money. So the money side of things actually runs primarily through a type of accreditor called an institutional accreditor. Almost all of you went to college probably, and in the background of that college is what's called an institutional Title IV gatekeeping accreditor. And the college needs to have the blessing of that accreditor for students to pay that college with the Pell Grant or with a loan. And about 75% of American college-going students have one or the other. These are the formerly regional accreditors. They're gatekeepers of federal finance and also most forms of state aid. And then separately, and this is the topic of today, and also a small number of programmatic accreditors, which in addition essentially sanctify the graduate or qualify the graduates for employment in licensed professions at the state level. So if you're a lawyer or a nurse or a physician, you essentially must be trained at an institution that's accredited by one of a few programmatic accreditors if you want to get a job under state sort of licensure associations. So gatekeepers are immensely powerful. They gatekeep jobs and they gatekeep money. So keep that in mind. That's what's at stake here. How do you build one? You know, I'll be brief, or most of you will leave this room and call your psychiatrist and be thankful that you don't have my day job. There is actually there's a law in the books. It's a regulation, actually. It structures the relationship under the Higher Education Act of the department vis-a-vis accreditors, and it does contemplate the formation of new accreditors of the sort we're talking about today, programmatic accreditors, and also the ones, the corner of this problem that I'm working on, which is institutional accreditors. It's a demanding law, as it should be. It requires you to form an accreditor, seat a board, it's intensely regulated stuff. You have to release an accreditation model complete with standards and guidance, and you actually have to go and accredit in the real world before you're an accreditor. It's a difficult pitch, if you can imagine it. I would like to accredit you, the institution. It's a form of accreditation of absolutely no consequence, but please help me because I have to train myself as an accreditor. It leads to what's called a petition. It's a very long document. It gets filed at the Department of Ed. It then goes through review by the staff, typically there. There's a series of reviews. It gets reviewed by a congressional advisory committee and eventually by the department. It's not a fun process. I don't think it's an optimized regulation, but it is viable. In theory, we've been at it for years now. I can talk much more about it, Bob, as we get into it. The important thing now is this department is receptive to reviewing, to adjudicating under the law, under this set of regulations, fairly interpreted and applied petitions by credible new accreditors. And so there's an opening here for accreditors to get built, to do the hard work of compliance with this regulation, and to come up and have a fair audition with the department. And I'll turn it to you, Diane. Thanks for being here.
Well, and just along those lines, just real quickly, so just do some table setting here.
Yeah.
The ABA is kind of unique in that it is both an institutional accreditor for freestanding law schools such as John's, and thus a Title IV gatekeeper,
As well. Yeah.
and a programmatic accreditor in that it is the accreditor of programs leading to a GD program, a JD degree, which implicates basic questions of state licensing and the right to practice law, which is a perfect segue to Diane and your thoughts not only on sort of the state licensing aspect of all this, but I'd also like to hear your thoughts on the inside, the department's perspective on all this as the regulator of accreditation agencies.
Great, thanks, Bob. You might not even remember this, but I met Bob Eitel. We were mere children during the Bush administration when I was the senior department official and the ABA was up for review. I don't know if you remember this, and we had to talk about this, and that's how I first met Bob, so it's great that here we are full circle. And in those days, the ABA was threatening to take down Georgetown University's law school because they had not built a new library, and the faculty wanted one. And it was just outrageous to us, and we didn't, Al Gore hadn't quite invented the internet yet, but we already could see that things were moving to an electronic means of research and sharing information, so it just was preposterous. Anyway, so that's how we first met and have been dear friends, and ever since then have worked 3 jobs together. So it's always great when I get to see Bob Eitel. So I think that the accrediting agency recognition program that exists today is fundamentally illegal. Now, this is a dangerous thing for me to say in front of a room full of lawyers, because I'm a molecular biologist. I am not a lawyer. But with Remembering Rocks, I hope to, convince a whole bunch of lawyers that maybe I'm right. I think it's fundamentally illegal. So you have to go back in history. Oh, and one other thing I'll say is, as a card-carrying Republican, it's Republicans that screwed it up. And thank God we have Republicans that want to fix it. But we have to take a little bit of the blame. So if you go way, way back, so accrediting agencies have been around for, over 100 years. They formed as social clubs. So the New England Association was the first one, and if you read the writings of the president, they were social clubs where the presidents of elite institutions got together with the headmasters of elite boarding schools to decide what needed to be taught in boarding school so that those students would have a pathway to an elite college education. Full stop. And so it was okay that they had standards that were bizarre at times, because you didn't have to join if you didn't want to, and the whole point of it was just to keep the students flowing. And what got you admission into the group was the educational pedigree of the president, right? I mean, I worked at Princeton. No offense, Stig. These people are thick as thieves. They all know each other, right? They all come from, at least in those days, they all came from the same social class. So these were social clubs, and their role expanded with the Morrill Act that basically started the land-grant university system. So these accrediting agencies were initially formed by the elite private schools in different regions of the country, basically to say, okay, these land-grant institutions are going to come out with vocational education. By golly, we are going to differentiate ourselves, we are going to protect liberal education, and we're going to show that we're better. So you have to kind of understand that this whole thing got started by elite institutions trying to establish themselves as better than these newfangled land-grant colleges that were, hold your breath, going to allow the children of middle-class parents to go to college. So that sort of sets the stage for how accreditors began. And all of that was okay, but then in 1952, when the GI Bill was reauthorized, Congress added a provision because the GI Bill cost more than Congress ever thought it was going to cost. And so when they reauthorized it in 1952, they had to close the field so that it wouldn't be so expensive. So they added a provision that said to serve a student who's using GI Bill benefits to pay for school, you have to be accredited by a recognized accrediting agency. So that was the first time federal law said these accreditors, they have a federal role now. And the Commissioner of Education was required to maintain a list. And so they used the word recognized because that's literally what it meant. The brain trust of higher ed people, who we call the blob, would come together and basically tell the commissioner, yeah, this is a legitimate organization. So to be a listed, recognized accrediting agency, it meant you were legitimate. You had an office space, you had some people knew your names. It was not a matter of, we like the schools you accredit, we don't like the schools you accredit. It was really a litmus test of legitimacy. And there was the rare university that needed this accreditation to survive, because many of the elite schools did not want to serve GIs, and there was the rare college that was dependent upon GI Bill funding to survive, right? So the whole process was voluntary. And I say this because when you read all of the rhetoric about accreditation, including the current Higher Education Act, it emphasizes the voluntary nature. Every accreditor, in their mission statement, in addition to claiming separate and independence, they will, their voluntary membership. it truly was voluntary because no school was going to live or die based on whether or not they could receive GI Bill funds. The same language was inserted when the National Defense Education Act was authorized, once again, to say if you want to get this funding, not only do you have to submit a really good grant proposal to do something interesting in science or foreign language, you have to be accredited. Again, no school depended upon this for its survival. It was a perk. You could get some research funding. When the HEA was passed in 1965, it also adopted the terminology of to participate in this program, you have to be accredited by a recognized accrediting agency. And again, the Commissioner of Education just maintained the list. When the HEA was written, financial aid as we know it was not authorized. So the original financial aid program was grants to states. And it was states that made the decision about how money was going to be distributed to schools. It was not a program that sent money through students to schools. It was fundamentally different. The point being that even when this language was inserted into the HEA, accreditation was fully voluntary. Most schools were not dependent on federal funding for their existence. And that was the case until 1992. And so one of the things that's really interesting about being old, as I am, is I actually watched this system change. I was the senior department official at the beginning of the change and then again during the Trump administration. So I've kind of seen the history. And it keeps me up at night, literally. Like, I did not grow up thinking I wanted to be an accreditation person. That was not my dream. But it
What?
Shocking. So the reason that I think the recognition process right now is fundamentally flawed is that it's not voluntary.
Just describe it briefly. What recognition process that you're talking about? What is the procedure briefly? What is that all about?
So prior to 1992, it was the Brain Trust got together and said, yep, you're legitimate, you got on a list. Thank you to then Secretary Lamar Alexander in the 1992 amendments to the HEA, the accrediting agencies got a new role literally as the responsible party because it was already clear that the financial aid program was a disaster. And so Congress wanted more money to go to it, but somebody else is going to be accountable. So the 92 amendments really emphasized this gatekeeping role over federal student aid. It also created a new recognition process, which now gave the federal government a very clearly defined role in approving an accrediting agency. And that fundamentally changed the nature. And when I was in the Bush administration, like, the department was still trying to figure out what it meant to approve an accrediting agency. So we're still trying to figure this out. I'm not a constitutional law scholar, but people will often say that is unconstitutional, and I don't know if it is or not because it's not, I don't know, I'm not a constitutional scholar. But here's why I think it's illegal. The HEA is abundantly clear that the federal government cannot use its role as a Title IV gatekeeper to influence the administrative or academic decisions of a college or university. And that's exactly what accreditation does. Because the government recognizes the accreditors, they have learned how to use that power as a point of control over accrediting agencies to dictate to them, to dictate to colleges how they should run the place and how they should teach. So this recognition process as we know it today has not always existed, but basically there's a set of rules. The accrediting agency has to participate in accreditation activities for 2 years. It then comes to the department, petitions for recognition. The staff review the petition. There's an outside advisory board that comes in. And so the senior department official gets a recommendation from the staff and a recommendation from this external body called the NASIKI. And that process is the most arbitrary and capricious process in federal government. I mean, it's crazy because the bureaucrats at the Department of Ed have created an entire system of rules that they made up from whole cloth. Basically, to prevent any new agency from being recognized because they're not going to get any more money or more staff, and it's just more work for them. And I say this having been on the inside. So for example, the law says that you have to have accredited or pre-accredited one school or program before you can be recognized. But as Stig is learning, when you go before the staff, that's not what they say. They say, oh no, you have to have experience accrediting at every level and in every kind of school that's in your scope of recognition. And you need to have enough members to support yourself financially. And they have this long list, and they make it an impossible thing to do. Because you can't be somebody's Title IV gatekeeper before you're recognized to be a Title IV gatekeeper. And for years, that was the staff standard. If you're not a gatekeeper, you can't come in. Well, you can't become a gatekeeper unless you come in. So during the first Trump administration, we promulgated regulations to at least give a pathway for new accrediting agencies, which the staff have completely ignored. So, Trump 2.0, enforce it. So basically, that's what happens. You go before the staff of bureaucrats, many of whom have zero higher education experience. Some do, some don't. And they come up with their own rules. And they hold agencies accountable for all kinds of standards that are not written anywhere, that are not in reg, that are not in statute. And they create an impossible dream, basically, because they have set it up so that you can't be it until you are it. So hopefully, between the changes in regulations and the administration, maybe they'll unwind some of that. But, only as long as we have a Republican administration, right? They will revert back to their old habits, as we already saw during the Biden administration. So this recognition process, it's important. You've got to go through it every 10 years as an accrediting agency. I have witnessed the staff using the process to take down 2 accrediting agencies that did everything like everybody else, and maybe had a few problems along the way, as do all accrediting agencies. But it becomes the targeting mechanism. And a Republican administration used it to target against the schools it did not like, and then the Obama administration used it to target a group of schools it didn't like. So both parties have done it. But I think it's illegal because it gives the department this long arm of control over the academic and administrative decisions of a college or university that the law prohibits. I also think that it is a violation of the Anti-Deficiency Act. Again, molecular biologist, so shoot me down if I'm wrong. The federal government is not allowed to accept any goods or services from a non-governmental entity for free. You can't take anything for free, and yet we give these private membership clubs total control over trillions of dollars of spending that the federal government issues, and they're a non-governmental organization and they don't get paid for it, which is not a suggestion on my part that now the government pays these agencies. It's just that I think accrediting agencies should do their thing and be who they are and go on about their business. But the role as a Title IV or a federal funding gatekeeper is the problem. And I do think it's a violation of the Anti-Deficiency Act that millions of dollars of service comes to the federal government from these accrediting agencies, and they don't pay for that service. But they sure use their position to impart a lot of wisdom upon these agencies. So I think there are some fundamental problems there. So that's the recognition process. We have institutional accrediting agencies. We have programmatic accrediting agencies. And I'm going to shift now to the programmatic accrediting agencies. In my lifetime, I have witnessed this role change, and it changed. So I was the assistant secretary the last time the Higher Education Act was reauthorized in 2007, even though the act is called 2008. That tells you how long overdue it is. Programmatic accreditation existed in a different form the last time the Higher Education Act was reauthorized, and here is why. It used to be voluntary, but in the 2000s, starting in the late 1990s, frankly, professional organizations that own accrediting agencies as subsidiaries realized, oh, there's some power for us if we can convince states and the exam administrators to limit access to somebody who is a graduate of a programmatically accredited school. Really, until the early 2000s, most states had multiple pathways to licensure. You could graduate from an accredited college, you could graduate from a programmatically accredited program, or you could have experiential learning. In the 2000s, all those pathways went away except the pathway that went through a programmatic accrediting agency. Sometimes the trade association led the effort, sometimes the accrediting agency led the effort. What did it mean for them? It meant more money in the bank because now every school had to get accreditation, and it meant that they could control the occupation. Not just the schools, they could fundamentally transform entire occupations because they held the key, to the kingdom for everybody who wanted to enter it. And if you think law school accreditors are bad, you have not met the nursing accreditors. I won't say what I'm going to say.
It's a family hour, so.
There are worse than law school accreditors. So these programmatic accrediting agencies started as a good thing, right? It was good to have a nursing accrediting agency to say, you know what, a nurse should probably know a little anatomy, a nurse should probably know a little pharmacology. When it was limited to academic content, it actually helped build the profession. It helped elevate the status of the profession. It helped the public trust with the occupation. The problem is that it went beyond that, and once programmatic accrediting agencies became occupational licensure gatekeepers, meaning you don't get to sit for the exam unless you graduate from a school we've approved.
As is the case in many states for the ABA.
I think all but 2 states for the ABA, about half of the states have adopted it for nursing, all of the states have adopted it for physical therapy and pharmacy. Once you have control of occupational licensure, then the accreditor can say, for example, no longer can you get a bachelor's degree in physical therapy to become a physical therapist. It's got to be a PhD. Oh, and by the way, it's not any longer than the program was as a baccalaureate. It was a 5-year baccalaureate. It's now a 6-year PhD. It doesn't meet any of the standards of a doctoral degree, but because the pharmacist and the physical therapist, they both did it, decided, oh, it should be a doctorate, thus it was. And when they made that change is when they also made the change that you could not sit for the licensure exam unless you went through programmatic accreditation, because there were schools that had bachelor's degree programs that wanted to continue them. So they became occupational licensure gatekeepers. In my mind, that means the secretary no longer has the authority to recognize them. And I tried to deny recognition to an accreditor on this basis and was overruled by the Biden department. Here's why. The HEA limits the secretary's authority to an agency that has a voluntary membership. And the agencies love in their mission statement to tell you how independent they are and that they have a voluntary membership. Once you are an occupational licensure gatekeeper, membership is no longer voluntary. You can't have a nursing program if your nursing graduates can't be nurses. And in most parts of the country, you can't have a law school if your law school graduates can't sit the bar. So I think, and I've shared this opinion with some folks at the White House, it'd be great if others would reinforce the opinion. I think the secretary should immediately withdraw recognition from every programmatic accrediting agency that serves as an occupational licensure gatekeeper because their membership is no longer voluntary. And I really think that by taking that recognition piece away, you would restore a truly voluntary system of accreditation where some law schools could choose to be accredited, and maybe that would be a mark of distinction with the students they wanted to attract. But Ave Maria would not be required to become accredited, and that would probably be a mark of distinction for the students it chooses to attract. So, I think, and then finally, I also think, again, the molecular biologist speaks, I also think that when you have these programmatic accrediting agencies and the secretary only recognizes one for an occupation, I think that's a violation of US antitrust law. I mean, tell me why it's not. you're talking about the entire profession of law, medicine, pharmacy, nursing, physical therapy, and one private membership organization controls all of it. There is no more competition because schools like Ave Maria, which probably would love to not have to be accredited, don't have that choice. So I think the Federal Trade Commission should be investigating whether this violates the antitrust. So I think I've given 3 legal reasons why it's illegal.
So we've got about 20 minutes left. I would like to get to questions in a bit, but I just have a few more questions for the panel. And I want to bring it back to Gail and this issue of the sort of the woke accreditation policy criteria. We've heard discussions about how the department plays this recognition role and how important that is to accreditation agencies for a variety of reasons. Why wouldn't the Department of Education just do a regulation that prohibits the ABA from doing what they're doing in connection with this woke accreditation criteria? I think there may be some federal statutory issues there, and I think you've contemplated a legislative fix.
Yeah, we've contemplated a legislative fix because at least my read of the statutes says the Department of Education is not supposed to be doing this sort of thing. And I think this is actually the single most important legislative reform item, on the accreditation issue, is to pass a law that takes the diversity issue just completely off the table for accreditors. The Supreme Court's decision in SFFA versus Harvard, it's going to be a dead letter unless, as long as accreditors can act as cartel enforcers, and that's what they are. They're cartel enforcers telling schools that by hook or by crook, they've got to come up with a class and a faculty that is diverse enough in the opinion of the accreditor. I think this is doable. More doable than a lot of the other reform proposals, some of which are great. There's been so much talk of accreditation reform over so many years. Just this one little thing, just give me this one little thing, and I think it at least potentially could get through, in part because the schools themselves do not have, as great a reason to oppose this as they do a lot of the other proposals. It doesn't, they don't want to be dictated to how to respond to the Supreme Court's decision. And under the proposal I'm talking about, if they want to cheat, they can still do it individually. If they can do it. If they want to come up with arguably legal but really aggressive ways to try to get around the Supreme Court's decision, they'd be able to do that too. But the one thing that wouldn't be allowed would be for the accreditor to tell them they got to do it. You got to do it by hook or by crook. So, from the standpoint of the typical law school or the typical, I'm not just talking about law schools here, I'm talking about all the accreditors. There is reason for hope here. That schools, if you put their nose in it and say, look, we're trying to give you more discretion, not less. We're trying to just bust the cartel. That's what we're doing. And I think this has a prayer, at least. And as I think I said a few minutes ago, Senator Jim Banks of Indiana has a Senate bill that will do what I think needs to be done. The bill also includes another issue that I personally wish had not been put in there. But you know how these bills go. Sometimes things get put in, they get taken out. So I'm happy with the half of the bill that addresses this issue. The House side has a bill too. And I don't think it's strong enough. It tells accreditors not to pressure schools to break the law, essentially. But that's not going to do it, because the accreditors are going to say, again, perish the thought. We would never ask you to break the law. Just do what we say. And that's not going to achieve what they think it's going to achieve. But again, I think there's hope here, and I'm not usually that hopeful on accreditation issues, so maybe I'm just suddenly in my old age gotten to be too excited and think that things can be done, but let's do this one, okay? Let's do this one.
So I think we've revealed this is a fairly deep and complicated subject. There's a number of themes that have come out of this in terms of what is wrong with accreditation generally, and then what is specifically wrong with legal accreditation, but I've heard issues relating to, in addition to the woke criteria requirements, issues of separation and independence between professional groups and the accreditation body, i.e. the ABA itself, and the council, which seems to plague other occupations, professions. There's issues of transparency regarding the internal deliberations of what agencies are doing, particularly the ABA. There's concerns about funding mechanisms for the agencies, who's paying them. A lot of them are funded by their member schools, which sort of raises perhaps a conflicts issue. Issues of expense. We haven't talked a lot about how expensive this whole process is, but John, I think you touched on that in your remarks. And finally, the failure to understand the mission of a particular institution or school, and John, you specifically have felt that. Unless I do want to give you guys an opportunity to say, additional things. The times move quickly, and then I wanted to open up to questions. So if anybody would like to jump in with a final comment.
Can I respond
Yes.
to the bill? So, I think legislative fixes are interesting, but I think Congress should probably just concede that if it's not a voluntary process, the Secretary doesn't have the authority to regulate it. But my big concern about the bill is, yes, DEI is the issue for law schools, but I can tell you for nursing schools, the issue is that the accreditors have threatened to remove accreditation from schools that do not require their nursing students to proactively counsel patients to get abortions. So your bill solves the problem for law school. It does not solve it for Catholic schools that want to have nursing programs. And over time, I've actually watched this cycle through where. So it's not just limited to DEI issues. They take advantage in other places. But I think if Congress just fundamentally said we only authorize a voluntary program, period, full stop, you get rid of a lot of those problems.
Yeah, I just want to say, don't let the perfect be the enemy of the good. We've only got a little bit of time. Everybody thinks that when their preferred candidate is elected, that's going to be the end of the story and everything's going to be hunky-dory forever. That never, ever, ever happens. And so I think there's a very limited number of days. I think this should be measured in days that to pass legislation. Just give me this little one. The other thing I wanted to say is that massive federal funding of education is the root of all evil.
Yes.
Once you start with that, you're going to have somebody to decide who gets the money and who doesn't. The centralization of education is the worst thing imaginable. I don't want the federal government, judging every single university in this way. That's why we have this system of accreditation, as being somebody else will do it. That didn't turn out very well either. And so, I don't know how to fix all of this, but I do know how to fix the one little tiny thing that I'm talking about. And that is we actually can, I think, if we try hard enough, pass this legislation. And I'd be happy to talk about other wonderful things we could do as soon as we do this one little thing.
All right, so if anyone has any questions, I'll invite you to come to the mic. We'll form a line, we'll continue the dialogue, but let's go to questions first.
Thank you for being here. David DeLugas with Parents USA. I'm an attorney, went to a top 20 law school. Question, why in a free market do we even bother with it? Why do we not let those who employ attorneys, whether law firms or consumers, decide their competence? I, for one, just would think if you had an apprentice in your law office, never went to college, never went to law school, that person may become a far better attorney depending on their inherent abilities.
You mean like
and the
Lincoln?
There you go. So
For example.
I'm a skeptic at the whole notion because I was at a big law firm. We had a law review from a major law school come in as a young associate. A year later, he's being asked to leave and find a job somewhere because he couldn't do the work. Law school is not necessarily preparation for the practice. And similar to medical, the different specialties, perhaps there is a necessity depending on what you're going to practice, whether you get to specialized training. But then again, I'd rather see the market do it than any institution.
Well, you raise an interesting question too. Law school has no, I think you said law school is not the practice of law. Really? I mean, clients might be surprised to hear that. Like, you go to law school to become a lawyer, and I think there is perhaps room for there to be, in addition to the academic aspects that we have now, a client, more of a client-centered type of legal education that might serve clients better, where students walk out of law school, graduating, and can take a deposition or try a case, which many of them, frankly, cannot.
But it's the conflation between accrediting agency recognition and occupational licensure that's the problem, right? The states say you got to graduate from a school accredited by a recognized accrediting agency that hands them the monopoly. And
Why do the states say that?
because the trade associations lobby the states, and the trade associations get a direct flow of money from the accrediting agencies, which is why I know it seems sort of silly to take the stand that I think the secretary needs to recognize she doesn't have the authority to recognize them anymore, because that's going to force the states to change their state licenses. So I know it's a roundabout way of getting there, but I'm not convinced that you can convince all the states, but they would have to do something if all of a sudden there was no recognized law school accrediting agency.
Hi, first I just want to say thank you all for giving your thoughts. I thought it was a very interesting discussion. My name is Michael Mackey. I'm a 2L at Suffolk University Law School in Boston. I'm also the president of their Federalist Society chapter there. So you sort of outlined this at the end of both of your remarks of sort of outlining the sources of the problem and some potential solutions. But my question is, and you guys were just discussing this, where do you think is the most plausible? Where is the solution going to come from? Is it going to be legislative? Is it going to be from the Supreme Court? Where do you see the most likely success of solving these problems? Where is it going to come from?
Well, I'll jump in and say something I probably should have said earlier. I would like every sharp mind in this audience and any other sharp minds to work on this problem, and that is, if we did away with the ABA tomorrow, that will not solve the problem, because the states regulate who gets to sit for their bars. And just to play that forward, a school like Ave Maria, we send a non-trivial proportion of our students outside of Florida. So we have a wonderful Supreme Court. I'm not just saying that because Chief Justice Muniz is in the audience.
It's true.
But I'm saying it partially for that reason. But we have a wonderful Supreme Court. I have no doubt that Ave Maria would be recognized by our Supreme Court. But would Michigan, in the absence of ABA accreditation, permit our graduates to, I don't mean to pick on Michigan, I just picked and so there is this interstate aspect. And in a way, it does lead to strange alliances, because I know the University of Florida is extreme, and Florida State and all the law schools in Florida are extremely interested in the question. Even if the ABA goes away, how do we craft a solution where students like you can graduate from a school in Massachusetts and practice law in Illinois? So to me, I don't know where that solution comes from. But that is the question that has to be answered. I mean, I think despite everything we've talked about today, doing away with the ABA as the sole accreditor is the easy aspect of it. So anyway, that's my 2 cents for what it's worth.
And I think the antitrust issue, right? So I spent 20 years in DC. I don't have a whole lot of confidence in Congress solving the problem. But I have seen, and we learned this from, the former Obama administration, learned how to sue agencies to get things done. And I can't believe I'm actually recommending it, but I think somebody needs to bring an antitrust lawsuit. And then, that the department has to consider, or the department itself has to initiate this. Because these monopolies, in what other facet of life are these monopolies allowed? And you're talking about trillions of dollars at this point. So I guess having been here long enough and maybe not knowing enough about the legal process makes me very naive, but I kind of think this, antitrust, anti-deficiency, let the Supreme Court, look at this, and it's preposterous. It's a preposterous setup. So,
I agree 100%, 1,000% with what you just said, but from the perspective of a law school that does not have Yale's endowment,
yeah.
If we have any uncertainty about whether our students can go out to a different state to practice law, the 3-4 years, whatever it would take to get to the Supreme Court, is an existential threat to our school. And I think even schools with endowments are risk averse. Law school deans are nothing if not risk averse. So the litigation, I'm for it, but there will be collateral damage if we rely on lawsuits.
We got to remember that the ABA accredits freestanding law schools, and that's their only accreditor. So no, if you don't have accreditation from the ABA, if you're freestanding, your students can't get financial aid through the federal government, and so there is going to be an accreditor somehow. And whenever you've got federal funding, somebody has to decide who's a university, who isn't, who's a law school, and who isn't. So one way or another, there's going to have to be such a thing. And it's a question of how do we make it work? The Antitrust Division at the Department of Justice actually looked into the ABA some years past, back when they made the stronger disconnect between the ABA and the ABA Council. And they wanted to make sure that, it's not just lawyers on this council making this decision, because lawyers are going to try to limit the number of people who get into the profession. So they were thinking about the antitrust issues, and they came up with the brilliant idea of let's get more deans and law professors, forgetting that we have labor union desires too, and you put a bunch of law professors on it, and what they want is perks for law professors, and so there's no perfect solution to all of this. Whatever solution we come up with is going to eventually be ugly and corrupt, and it's really ugly and corrupt right now. But some people have said, let's have states accredit, universities. I'm not talking about law schools here. I'm talking about basic gatekeeping, and having states do it. States end up having a conflict of interest in that. Can you imagine the governor of North Carolina saying, we're going to de-accredit the University of North Carolina? They'd impeach him. So everything has to be worked out in great detail, and no matter what detail we come up with, it won't be perfect. But we can make it better than it is now.
Steve?
I'll just point out that one available pathway for reform is just the very, very blue-collar work of operating inside this unsatisfying architecture that we're describing. Assume for a minute that HEA persists. Assume for a minute that the legal strategies invented by the genius molecular biologist sitting next to me. There appears to be a young lawyer in the front row taking furious notes, Diane. I don't know. Great, exactly. Look, there are ways to view reform in deep structural ways through statute, through the courts, et cetera. In addition, and sometimes I think this is unsatisfying, but most days I'm just required because of my day job to really believe in this work, which is there's also an opening now, Bob, I really appreciate you talking about this, which is let's go build some new accreditors to put pressure on this inside the status quo as we find it. We might be surprised where if there is to emerge, for example, a new law programmatic accreditor over in the world where I operate, an institutional accreditor that can get interested in innovation and the formation of new colleges and so on, that is incremental work inside the prevailing architecture of the HEA and the patient as we find it, so to speak. But I think there's an opening to potentially also do work there in very applied ways that can be powerful.
Let's move quickly to
Thank you.
Yeah, absolutely. I think we have one final question.
Okay. Hi, I'm Jeff Leach. I'm a member of the Virginia Bar. I went to GMU Law School. And I can understand the argument for why you need to have quality control, of course. But it seems to me, as someone mentioned, that things like bar exams, where the proof is in the pudding, would be the solution for that. And also, some states recognize that, about 10 states, including Virginia, allow an apprenticeship program, which I think sort of undermines the entire idea that you have to have, you know, some sort of outside accreditation. Wondering what can be done for that, but also, what would it look like if you broke up the monopoly, if you didn't just have the ABA, but you introduced many different people? For example, a notary public can affirm that a signature is, you know, they can be an accreditor of this signature. There can be an innumerable number of notary publics. So why can't there be, you know, a large number of competitors in that field, and maybe somebody also authorize, you know, looking at those individual groups? But would something like that work?
I mean, I think that would be a great solution if you could get the department to recognize more than one accreditor. And the challenge there is a lot of states mention the ABA by name, and so you know, you don't even have the choice. So, you know, again, I think that's the problem with the monopolies, right? I mean, if the secretary did recognize 4 different law school accreditors and you truly did have choice, I think some of this would go away because the Catholic university law schools could form their own accrediting agency. But it's this catch-22 if you can't be an accreditor until you're an accreditor, which we cured with the regulatory solution in the first Trump administration, and now there's a chance for the second one to actually make the staff do their job.
And I might add that the current administration has indicated that they will engage negotiated rulemaking on accreditation and perhaps revisit some of these issues in the coming year, if not sooner. Well, I wanted to thank the panel. I thought it was a great discussion. It's a deep subject. We just scratched the surface. Really appreciate you being here, and I thank the audience for watching. Thank you. Thank you.